May it please the court?
Court is pleased.
Gentlemen. Somewhere during the admission of crime scene photographs and the defendant's phone records, we stopped talking about the children that were killed in this case. It was necessary to demonstrate to you the level of animosity and resentment that the defendant felt for his wife in an effort to show you how the premeditation developed in this case. Somewhere in that intellectual exercise, though, we lost sight of the two tiny children that were brutally murdered on the morning of October 23rd, 2013. That stops now. It's the murder of these children. It's the murder of these children that makes the defendant eligible for the death penalty. So their loss will be the sole focus of this part of the trial. Ladies and gentlemen, thank you for your time and attention during the first phase of this trial. As we explained to you throughout the process, this is a two-phased proceeding. During this phase, the penalty phase, we're going to be talking with you about the nature of the crime, the characteristics of the victims, and the history of the defendant. Though we will be presenting some new evidence, the evidence is only meant to supplement what you already know. As part of this process, you are allowed to consider everything that has been presented to you in the guilt phase of the trial. We would suggest that you consider these additional details and then reevaluate the things you know or the things you think you know about the individuals involved in this case. As we discussed in opening, the information presented here in this courtroom is no different than the information presented to you in your daily lives. In order for the information to have any meaning at all, it must be viewed in the proper context. At this stage of the proceeding, we're able to give you more information than we could before. You are allowed to know particular things about the history of the defendant, a history that may change the way that you previously viewed him, a history that may change his relationship with Yesenia Suarez. It may change his role in the home and the kind of influence that Yesenia Suarez was concerned that the defendant would have over her children. The kind of influence that could affect them during these formative years. It will give you a greater appreciation for who the defendant is, what he is capable of, and how long he has been living a violent criminal lifestyle. No doubt it will change the way you perceive these killings. No doubt it will change the way that you see the person capable of committing these terrible crimes. We give you this information now, because it's relevant to sentencing, and because it gives you a greater perspective of the defendant as an individual. The function of a jury or a juror in the first phase of the proceeding is to determine whether the state has proved its case beyond and to the exclusion of a reasonable doubt. You are asked to examine facts and evidence necessary to make a finding as to whether the defendant committed a crime. Now your role will be entirely different. Your role as a jury or as a juror is to make a recommendation about what happens next. A recommendation of death will allow the court to consider additional information and evidence, and then the court will make a finding about the appropriate punishment in this case. A recommendation of life, or anything short of a unanimous verdict for death, will ensure that the proceedings end here and the defendant will automatically receive a punishment of life incarceration. As I told each of you during jury selection, there is nothing in the law that requires you to vote for death. In the state of Florida, the death penalty is reserved for the worst of the worst. In that respect, the state would ask you to consider whether the defendant fits within that category of criminals. Specifically, we're asking you to consider, should the defendant be sentenced to death for the killing of two innocent children in a violent, brutal, senseless manner for the sole purpose of evading the law and escaping justice. So let's take a moment to consider some of the evidence that was presented in the initial case. Evidence that will not be represented here and will only be the subject of additional comments and additional argument by the lawyers. At the time of her death, Talia Otto was 9 years old. 9 years old. She was a bright, curious, happy child. She had aspirations and she had goals. Even at this young age, she was already talking to her grandmother about her plans to graduate from high school and go to college, that one day she wanted to become a vet and help the animals. And she had the intellectual ability to back it up. She did. She never missed school. She loved to learn. And just this year, she earned an advanced reading award presented by her principal, Ron Nathan. Her love for school was no doubt a result of the summer activities that she and Sabrina Newell and her mother did on a daily and weekly basis. Trips to the library to check out their favorite books, to see what learning is really all about. Talia was the pride and joy of her grandmother, Felicia Perez. Many of you are parents and grandparents, aunts and uncles. You know the joy and love that automatically attaches to a child at birth. Felicia remembers that feeling with Talia. But today she'll be talking about the devastating loss of this brilliant child, the sense of loss that's rippled through her family and through the community. Not only was Talia active in her family, but also active in the church. She had many friends, and she recently started making more as she started cheerleading and discovering herself and new activities that brought her joy. Elijah, her little brother, was much more introverted. He was 8 years old. And at 8, he had not yet started to develop the part of his personality that would drive external interests. He was still his mommy's baby. And he stayed closer to home than his sister did. He was shy. God, he was shy. But he loved his aunts and uncles and grandparents without bound. And like Talia, Elijah loved learning and was finding success in his early years of school. Because they were only 10 months apart, the two kids were enrolled together. They were in the same class. But though there was a gap in their ages, you wouldn't know it. Even at this young age, Elijah was able to keep pace right at his sister's side. Elijah was Felicia's beautiful grandson. And he was the young boy that would carry his father's name. When he was born, everyone knew that he would be special. At this point in the trial, you haven't had a chance to meet the children's father. Today you'll hear from Michael Otto directly. He'll tell you about the pride he felt in his children. And though his relationship with Jesse failed, his love for his children never wavered. He'll have an opportunity to tell you what it meant to become a father. He'll have an opportunity to tell you what it means to mourn the loss of these beautiful souls. His feelings will stand out in sharp contrast to the feelings of this defendant and the events of October 23rd, 2013. The evidence has already shown that while the defendant may have spent time with these children and may have even been responsible for them at points, he was not their father. You see, there are silent promises made the first time that you hold a precious little being. Wrapped in his arms and before the children could know the true dangers of this world, Michael Otto promised to love and protect his two little babies. From the evidence during trial and your finding of guilt in this matter, it's clear that the defendant never made such a promise. Reading back over the text messages in this case, it is abundantly clear. It is abundantly clear that the defendant's relationship with Jesse was failing. But what wasn't obvious on the first reading was the way that the defendant felt about his relationship and role with these children. Look back at the messages. Reevaluate what you think you knew. See for yourself the resentment he felt at being saddled with these little obligations. How many times he complained that his life had changed. More than once, he said he gave up everything for her, and that while she was out living life or having a drink with a coworker after hours, he viewed the children as an impediment to his freedom. He saw Talia and Elijah exactly the same way during the early morning hours of October 23rd, 2013. The evidence has clearly shown that he killed the mother of these two children in a fit of rage. And then once she was gone, the children were killed as a matter of convenience. In order to escape detection and avoid a certain arrest, he eliminated the children. Whether they were witnesses to what happened first, or they would simply wake up and want toast the next morning, they were going to be questioned, questions he couldn't answer. He removed them from this earth and forever took them from the loving arms of their family because he didn't want to get in trouble. Rather than face the consequences of his actions, he punished two little children for their mother's choices and then killed them so that they would never tell what he had done. Much as the state had to prove the crimes beyond a reasonable doubt, the state is required to prove certain aggravating factors beyond a reasonable doubt. And to this point in the trial, you've heard little about the circumstances that make a person eligible for death. The law has considered all of the many ways that first-degree murder can be accomplished and set forth a list of things that make certain crimes particularly worthy of consideration for death. There are particular titled aggravators listed by statute, and we'll talk about them now. We will refer to them from this moment forward as aggravators, and in this phase of the trial, we will prove the following aggravators beyond and to the exclusion of a reasonable doubt. Each first-degree murder, let me make this clear, each first-degree murder has the same list of aggravators. The list of aggravators for Elijah are 5 in number. The list of aggravators for Talia are 5 in number. Total of 10 aggravating factors.
Yes. Ready? May proceed.
Thank you. The list of aggravators is 5 in number for each of the children and 10 in total. The first one is that the victim in this case was under 12 years of age. In the first portion of the trial, you heard competent, substantial evidence that Talia was under 12 years of age. You heard the same competent, substantial evidence that Elijah was under 12 years of age. The indictment contained language that the children were 9 and 8, respectively, and the defendant was convicted as charged. During the penalty phase, there will be no dispute as to this aggravator or its existence. The second aggravator, that the victim was particularly vulnerable because the defendant stood in a position of family authority over the child. And when you consider this aggravator, you'll find that it makes sense. That the law would consider victim vulnerability and the relationships and bonds that exist between family members to make a crime worse, one crime worse than another, to make this murder particularly deserving of the death penalty. Much like children run to their parents' bedroom when they have a nightmare, children look to their parents and step-parents for protection, love, and support. There is no dispute that this defendant had a family relationship with these children, just as there is no dispute that they should have been able to trust that he would never do them harm. Number 3, the first-degree murders were committed for the purposes of avoiding arrest or preventing lawful arrest. Given the circumstances of the killing, given the close proximity of safety at their grandmother's house, and given the heated exchange between Yesenia Suarez and this defendant, there is really no other way or reason that 2 children, 8 and 9 years old, can or would be killed. Number 4, the first-degree murder was committed in a cold, calculated, premeditated manner without any pretense of moral or legal justification. Under these circumstances, there can be no other explanation. Yesenia Suarez had an affair. What did the children have? The children were killed by this defendant to eliminate them as witnesses. You'll get a series of definitions from the judge in this penalty phase, just as you did in the guilt phase. One of the things that he'll define for you are the terms cold, calculated, and premeditated. Cold means that the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit the murder. Not to get away with it, but to commit the murder. You've already found that this killing was premeditated, but this aggravator requires a heightened premeditation that's demonstrated by a substantial period of reflection. You remember in the first phase, that premeditation could form in the blink of an eye. This time it takes a little bit more. In order to find this aggravator, you'll have to find that there was a substantial period of reflection. The law will not define substantial for you. I'm sure that Mr. Johnson will have comments in his closing about what substantial might mean, but substantial is in the eye of the beholder. From the facts of this case, it's hard to say that the defendant's conduct is anything else than cold, calculated, and carrying this special kind of premeditation. When a child is killed as a witness elimination, that would seem to satisfy the legal requirements. When a second child is killed for the same reason, the proof becomes overwhelming. Number 5, the defendant was convicted of a felony involving the use of threat or of violence to another person. This is really kind of a 2-part presentation for the state. The first part, you already know. The defendant has been convicted of a felony involving the use or threat of violence. He killed his wife. The murder of Yesenia Suarez qualifies under this clause, under this aggravator. The fact that she was killed at or about the same time is sufficient. But there will be new evidence introduced to you during the penalty phase of this trial. Evidence of a defendant's prior violent felony. In just a little while, you'll hear from a man named Eric Preolini. Mr. Preolini used to live in Davie, Florida, down near Miami. He'll describe to you the circumstances by which his home was invaded. He'll tell you about 3 masked men, including this defendant, who forced their way into his home, held him down, taped and tied him, used a gun to threaten his life, actually put it to his head, and then stole the valuables from his possession. You'll hear about this violent encounter and the atrocities committed during this prior violent crime. And you'll hear that the defendant did this about 20 years before. You'll hear that the defendant has been living a violent criminal lifestyle since he was a young man. And so to summarize the 5 named aggravators and let you know that they can be applied to the deaths of both children, they are that the victim was under 12, that the victim was particularly vulnerable because of the relationship that existed between the defendant and the children, that the first-degree murder were committed for the purposes, both murders were committed for the purposes of avoiding arrest, that the murder was committed in a cold, calculated, and premeditated manner, without any pretense of moral or legal justification, and that the defendant has been previously convicted of a felony involving the use or threat of violence to another person. Ladies and gentlemen, the facts of this particular case, make the defendant eligible for the consideration of the death penalty. We started talking with you in jury selection about your feelings on this topic, and we determined that each of you has the ability to fully and fairly consider this punishment. We expect that you will follow the law as it is explained by the court, and that you will have a conversation about the merit of this sanction as it applies to this defendant. Keep in mind that this decision is one that you make as an individual rather than a group. This is a personal decision, and it's only when each individual votes for death that it even advances to the next part of the proceeding. In the next part of the proceeding, the judge will make additional findings and may rule regarding the punishment. But at issue here before you today and over the next several days are the character of the defendant and the characteristics of this horrible crime. As you listen to the evidence presented here and later make your determination, we would like to point out one thing that will not be offered again as a matter of proof in this phase. It was presented here in the first phase, but you can certainly use it for your deliberations in the second. Most children naturally consider their parents' bedroom a place of safety, security, and comfort. It's a natural refuge. For Talia Otto, it was a kill room. It was a dead end. Based upon the blood evidence in this case, we were able to establish that 3 violent bloodshed events occurred with Talia Otto in her parents' bedroom and in her parents' bathroom. The first occurred in the master bedroom just outside the bathroom. The second occurred just inside the bathroom. And the third occurred as she ran a little bit further to her demise. What we were told by Leroy Parker during the guilt phase of this proceeding is that Talia was moving deeper and deeper into the bathroom, lower and lower to the floor with each of these events. What we were told by Leroy Parker is that the final event occurred at a level that was on or near the floor. And again, because of the minutiae of this trial, it's easy to lose sight of the events that occurred. A trusted adult who should have loved and protected these precious babies brutally slaughtered them in their own home. Toledo Otto is literally beaten on the floor. And when you consider the argument that the defendant eliminated these children as witnesses, make sure you consider, make sure your consideration of penalty phase evidence and your conversation about the appropriate penalty in this case includes these points. That she was literally beaten on the floor.
Okay.
When the state asks you to return a verdict imposing death in this case, it has everything to do with the way and the reason that these children were killed. Please pay close and careful attention to the presentation that will occur over the next few days. We are confident that when you consider all of the evidence, you will find that the only appropriate sentence in this case, the only appropriate punishment for this man, is the imposition of the death penalty. Thank you.
Thank you.